This is Lázaro Cárdenas from the law offices of Patel and Sotes. I handle loss mitigation for the firm, particularly loan modifications and short sales applications, as well as deed in lieu. What is a deed in lieu?
A deed in lieu is literally is a way to give the bank the deed to the property and to walk away not owing them a penny. Now you have to be careful. Certain deed in lieus done by clients don't have that clause in there where, let's say that they give the deed back and there's a deficiency or there's still money owed. You want to make sure that you're protected against what you owe the bank. So what you have to do is you sign over the deed. The mortgage company then releases you from all the commitments and obligations in the note and mortgage. So that's important to make sure that those documents reflect that, it's stating that. So deed in lieu is another option. Now, obviously, my favorite option, but it's sometimes not available, is if the property has equity. And if there's let's say the amount owed on the mortgage is $200,000 and property value is $300,000. Let's say client doesn't want to keep the house, wants to walk away. Well, that's perfect because you don't have to do a short sale. And a lot of people think you do. What you do is you list it, you get a contract, and you conduct a full closing. And you use what's called the equitable right of redemption, which is paying off the exact amount of money you owe, taxes, fees, interest, etc., principal. And then that will dismiss the foreclosure action, it'll pay the mortgager back, and all of a sudden you've now sold the house and you have money left over.
So foreclosure doesn't force the person to do a short sale. They can put it on the market and sell it regularly.
They can, yes, as long as they have enough to cover all the costs of the closing, which with certain of our clients we've been able to do that. I mean, that's great, but other clients not so much. You have to pursue short sale or these other loss mitigation options.
What's the difference between a short sale and a regular market sale?
Sure. So a short sale requires you to get bank approval, right? So you submit the application to the bank, and the bank will tell you if the numbers work. So the bank will tell you what their loss is going to be and how much they're willing to take as a loss. The seller, our client, walks away with nothing, right? So because all the money's going to go to the bank. And what our seller gains out of that is there's no foreclosure against them, and if it's worked out correctly, there's no deficiency, which means they don't owe the bank anything. That's an ideal short sale situation. Now, a regular sale is different. You don't need the bank's approval. New Jersey allows you to have, or it's common law, equitable right of redemption, right? You are allowed to pay the mortgage company back and redeem your interest in the property, free and clear, as long as you pay them every penny back. And so with a full sale, that's exactly what you're doing. You're selling the property and you're covering that redemption amount. And therefore you get money to walk away as long as there's money left at the closing.